Welcome everyone to First Thursday. It is September and I am sitting in sunny South Florida waiting for Hurricane Irma to come pay a visit to us. So I feel like I'm on a desert island and this is my last broadcast before the storm hits. It's going to be a good one. I'm excited. And for some of you, you might have heard this before. For some of you, this will be brand new. If you've heard it before, listen again, because I can tell you, you always will pick up something different each time you hear it, because there's a lot of subtleties in what we do, but they make a big difference when you're really trying to vocalize this to a client, when you're really trying to help a client understand how this works. It took me quite a long time to develop how I talk about asset protection. And you'll see I'm actually doing this in a very specific way. And it's the same way that I would encourage you to learn how to do it with your clients, because it sets the stage for them to come to their own conclusions about what the best asset protection structure is for them. So if the content is a repeat for you, pay attention this time to the way in which the content is organized. And if I can encourage you to adopt that, at least in reference to how you talk about asset protection, I think you'll find that it's very effective. It's a very, very good way to communicate about how asset protection really works. So let's get started. Of course, my name is Douglas Lodmell. I'm the co-founder and managing partner of Lodmell, and this presentation is put on by the Asset Protection Council. I'm the founder of the Asset Protection Council, and that, of course, is our affiliate attorney network for Lodmell. And our goal is to teach you and to co-counsel with you on asset protection cases so that you can get up and running immediately. And you don't have to go and figure this all out on your own. We've already figured it out. We've been doing it for 20 years. We know how to do it. We know how to execute on it. We know how to communicate it. And we know how to add this part of this practice area to your practice. And I really encourage you to just take advantage of all that knowledge. So this is adding asset protection to your estate planning practice using the bridge trust. So what's the problem? The problem is that clients are afraid of the uncertainty of a legal system. And I know this because clients come to me usually when they have had something that has caused that fear to rise to the top. So clients understand that the risk of litigation is scary, and they are starting to figure out what they can do about it. The internet has created literally the self-education society, and they're out there, they're figuring it out. But they're figuring it out about 20% of the way. They don't catch it all. And what they come to you for is they realize it's complicated enough that they need an expert to actually help them to navigate the waters. And that's what we're going to teach you to be when it comes to offshore and domestic asset protection, is the expert that can help them navigate this very confusing area of law. Therefore, you need to be the source of that information. You need to understand it so that they can get it from you, and when they get it from you, they're gonna work with you because you're the authority. So first, you need to understand, why does asset protection work? Well, it works because if the pot of gold at the end of the rainbow is not available and the plaintiff's attorney sees that it's not available, what is their interest in spending their firm's time and money to pursue it? So we take the carrot off of the table. And that's the overwhelming reason it works. That's why people with no assets don't get sued. So we effectively make our clients unattractive by removing their assets from collectability. Now, in order for this to be true, whatever you set up needs to be seen as virtually impenetrable. You have to skillfully manage it. You can't just go in there with a big hammer and just tell everybody to go pound sand. You've got to very skillfully manage how and when you divulge information and what happens and how this goes, so that you let the poker game evolve to the point where when you are making your bet, it's respected. You can't have any obvious vulnerabilities in the plan. Certainly nothing that would be cause for another firm to see an opportunity to just create a bunch of billable hours. And at the end, it cannot be a bluff. It has to work. So, we're actually not bluffing when we go to showdown with the bridge trust. It works. We like to not go to showdown because it's a lot easier to win that poker hand before we actually turn the river card, because you'd much rather win before that trial, before all that expense. But if we get to that and there ever is a judgment against our clients, the planning will work, and that is critical. So what do clients want? Well, they want it to be effective. They want to have control of all their assets, of course, till they die and beyond. They want the cost, well, they want it to be free, but they know it can't be free, but they do want it to be reasonable. And they don't want any compliance or as minimal amount of compliance as you can possibly deliver to them. So they want it simple, easy, cost effective. That's the bottom line. So what are the tools that we have in our toolbox available? We have the traditional tools like the limited liability company, limited partnerships, which I call an asset management limited partnership, but it's known as a family limited partnership. It's just, this is a specific partnership designed to protect assets. And then we have the asset protection trust. And we're going to spend most of our time today on the asset protection trust because that's the real key component. That's where you need to be super educated and be able to understand all the complexities and subtleties of it. The LLC is a straightforward tool. It's great for risky asset. It segregates asset into separate LLCs. You can put the airplane that the client has in one LLC, his office building in another, the strip mall investment he has in another, and a business idea that he's started in another. You segregate all those into separate LLCs. That's the pretty traditional use. LLCs are fairly good tools. They have charging order protections, and they're certainly valuable, and I use them extensively. And for most clients that have a wide variety of assets, they'll have quite a few LLCs. The asset management limited partnership is the holding company in this structure. So it's going to be where we are going to consolidate the family assets. So things like cash and brokerage accounts and investments and so forth can go directly in there. So the account at Charles Schwab or Merrill Lynch can be held by the asset management limited partnership. It can also hold the LLCs and the other companies that the client has created for their assets or for their businesses. It adds yet another layer of charging order protection in Arizona, because Arizona is where we would base this tool, and Arizona has great charging order protection. They've been very specific. They've really taken the bull by the horns and protected the effectiveness of their charging order in both LLCs and limited partnerships. Even single member LLCs in Arizona can enjoy charging order protection. And this is the opportunity as well to include the family into the planning. So the kids and any other family members that you want to be part of the planning can be part as limited partners. Again, no control. And most importantly, this is the place that we connect the asset protection trust to the plan. And if a client wants, we can make this tool private. So we can make it to where who the members are of this is just not seen. And we do that by simply adding a Wyoming LLC as the general partner. And ultimately, that creates a privacy shield. So anybody looking at the assets or an account or LLCs owned by the asset management limited partnership will not see the underlying partners, not the limited partners and not the general. They'll just see a Wyoming LLC serving as the general partner. So let's talk about the asset protection trust, because this is really the key to the plan. This is really what causes you to have the true protection, that get out of town, get out of jail free card if push comes to shove. Assets can be moved outside of the U.S. court system. That's the purpose of an asset protection trust, at least in my book. It radically enhances the domestic asset protection structures. So you would use it with the asset management limited partnership and the LLCs. It's not limited to a specific risk. So it's not just, this set of liabilities like liability insurance. It's any risk, absolutely any risk, because we're really just dealing with the assets themselves. Again, privacy. This trust is not registered in the United States anywhere where it can be found, and it is very private. So when it comes to asset protection trusts, we really have to define, and this is where I would say pay attention to how I'm going to actually talk about this, because I'm going to talk about what they are first. What an asset protection trust is it's a self-settled spendthrift trust. That's what it is. So we're all familiar with self-settled trust. Every revocable living trust out there is a self-settled trust. The difference is a revocable living trust is not a spendthrift trust, meaning that you can just simply revoke it, and there's no asset protection features to it. An asset protection trust is a spendthrift trust, which means two things. It's irrevocable and it has spendthrift provisions. So how do we get irrevocable and spendthrift provisions in a self-settled trust where the clients are both the settlers and the beneficiaries? There's two ways. We can do it internationally in one of the jurisdictions that has passed an international statute that allows for this, or we can do it domestically in one of the 17 states that has passed a domestic statute that also allows for this. So let's talk about both. The Cook Islands Trust Act, and we're going to go over the Cook Islands because they were the first country to create a statute. So they are still the premier country to this day. They are the leaders in the industry. They certainly have the most experience, and they've been the most progressive about keeping their Trust Act current and up to date. So I like to use them as the example, and I also like to use them as the actual product. So this Trust Act was created in 1984. There is a statutory non-recognition of any other countries or courts, judgments, or judicial proceedings. So the Cook Islands statutorily is unable to recognize a U.S. judgment. If you do come down to the Cook Islands, you're starting from scratch. There's no bringing anything down that will mean anything in the Cook Islands. Why? Because they're statutorily prohibited from recognizing any other court orders, documents, proceedings, anything. So anything you do down there is a start from scratch. By the way, you're going to have to prove any case you have down there beyond a reasonable doubt. And anybody who grew up in the era of OJ understands how difficult a burden that is. It is just incredibly hard to meet that burden, and certainly for a civil case, it's almost unreasonable to ask someone to meet the beyond a reasonable doubt standard, which just tells you how serious the Cook Islands are in protecting the trust assets. There's no contingent fee attorneys, so you're not going to be able to go down there and convince some attorney to take this case for free, especially because the chances of winning and proving your case beyond a reasonable doubt are slim to none. Once you file a claim down there, you can't amend it, so you can't go down there, figure something out, and then amend it. You'd have to start over from scratch. And the statute of limitations is also short, so by the time you even got there, likely you're prohibited from even starting. But even if you get a chance to start and then you find out something that really does have some legs, you would have to go back and start over again. And if the statute is then run, well, then you're out of luck again. If you do lose, you're going to pay the legal fees and costs of the winner. So you have a financial disincentive. You have a real risk of trying to go down to the Cook Islands and attack a trust. And we just talked about statute of limitations. It's 2 years, 1 year for transfers. So very short, very hard and fast, not something that you can expect to get a lot of help from if you're trying to sue. So what are the upsides? What's the pros of the international option? Well, clearly effectiveness. I mean, I personally, having practiced in this area for the past 20 years, can think of nothing more effective than a Cook Islands Asset Protection Trust. It's just extremely effective. So my feeling is if my client is really facing a very real threat, which I have many clients that have faced many very real threats, I want to be in the Cook Islands. I want to be where the protection is the most tested and the strongest in the world. What are the cons? Well, the cons are, of course, the Cook Islands, you're not going to be in control of that trust. You're going to have a trust company in the Cook Islands in control, and that's a con from the client's perspective. Compliance is a real burden. You have a significant amount of compliance requirements from the IRS. So you have 3520 and 3520A, which apply to foreign trusts. You also have all the FACTA, FinCEN 114, and the disclosures around that for any foreign accounts that the trust would have, which, of course, if you have a trust offshore, you should have offshore accounts. Otherwise, what's the point? So you can figure, it's going to be a fair amount of compliance and disclosure to the IRS, and of course that costs. There's significant costs to having an offshore trust. I tell clients to budget between $5,000 and $10,000 a year, closer to 10, to maintain and manage an offshore trust. And that's if nothing really heavy is going on. If something heavy is going on and the trustee is required to do a lot, then it'll be more. Trustees bill an annual fee, and then they bill by the hour like a law firm. So the more you ask them to do, the more it's going to cost you. So this creates real challenges for clients. So they have to get comfortable offshore. They have to deal with the reporting requirements that we just talked about, and they have to deal with the fees and the costs. Again, from very real experience, I can tell you that unless they're actually defending the trust, unless they're actually there and that trust is providing a very real, very present benefit to a very real present threat, unless that's going on, most clients get very tired of the compliance and the fees very quickly. And they will typically cancel the trust once the threat has gone away because they just don't like it. And that makes the sustainability of this option really questionable, because it's hard to get a client to start a trust when there's nothing going on, pay those fees and costs, and keep it in place for many, many years under the potential that he might need it someday. It really is a challenge. And so most people who do international trusts only, maybe do 10 a year, because there's just not that many clients, and again, there's quite a few that are dropping out every year. So it's a very real problem. What about the domestic option? Because the domestic option really does solve some of these problems. It's great. It is a self-settled domestic asset protection trust, which has become known as a DAPT. They are newer, started in 1998 in Alaska. We now have 17 U.S. states that have some form of DAPT legislation, all the way down to Michigan. I mean, it's kind of like everybody's jumping on. And again, they're often paired with an LLC or a limited partnership to provide that charging order protection. So they're typically used in a very similar structure. So what's the upside of the domestic option? Well, there's no offshore comfort component. You don't have to help a client get comfortable offshore. You don't have the foreign compliance requirements. You don't have the FACTA, you don't have the FinCEN, you don't have the FBAR, you don't have the 3520. Those are all related to foreign. So you would just have a minimal amount of recording, just a tax return for the trust. That's it. And it may be less expensive. And I say may because this is all over the board with the domestic attorneys. These forms and trust boilerplate are available all over the place. Virtually any trust company in the U.S. who's promoting asset protection trust will give you forms. I've seen domestic trusts as low as $3,000, and I've seen as high as $30,000. So it's just all over the board what the cost of these are. So what this means is, from a compliance standpoint, that's a real upside. Cost, let's say yes, that's probably a pro compared to the offshore trust, because typically you're going to find it at less than what an offshore trust costs. And certainly from an annual maintenance, it should be less. What are the cons? Well, the cons are effectiveness. And I'm sorry to say this, but they have just proven over the shorter period of time than the foreign trust to be much less certain, much less effective. So we have a lot of cases in domestic asset protection trusts where trusts have failed completely. Assets have been completely turned over. There's no way for Nevada or Alaska to completely disregard a judgment from California or Texas. We have the U.S. Constitution, Article 4, Section 1, which is the full faith and credit clause, which requires the states to recognize the other states' laws and judicial proceedings. So it's really a diametrically opposed system to the Cook Islands statute, which is statutorily prohibiting recognition of another jurisdiction. So it's very hard for Nevada or Alaska or Delaware or any of those 17 states to just say, hey, we're totally safe from all the other states. And the case law is proving that out. And it's just creating more uncertainty. And that's the problem in the first place, is the uncertainty. So to me, a solution that is almost as uncertain as the underlying case itself is not a real solution. You also have the control issue. In fact, if you're even going to attempt a domestic asset protection trust, I would argue that you have to leave the client with less control than in any other circumstance, because you're now asking a U.S. judge to respect this trust based out of Nevada, and that the client doesn't have control. You better have drafted that thing with the client's hands tied behind his back, blindfolded, in a box, and underwater. I mean, and clients are not really excited about that. They don't like not having control. So in my book, unfortunately, the domestic trusts are not a tool that I use. I just don't think that a pure domestic trust standing alone in any of the U.S. jurisdictions that offer them is a good tool for virtually every client that I see come through my door. And this is especially true when we compare it to the bridge trust, which we're going to talk about next, because it truly is giving them a better option. And why take a lesser option when there's a better one available? So remember, what do clients want? They want it to be effective. They want to have control. They want the cost to be reasonable, and they don't want any compliance. So what is the bridge trust? The bridge trust is a self-settled spendthrift trust. It's actually registered offshore, so it is a foreign trust from the standpoint of registration, but it is for the purposes of 7701A30E, which is the code section that defines whether a trust is foreign or domestic. It is considered a domestic trust. So it is bridged back, which is why it's called a bridge trust, because it's bridged between an offshore jurisdiction and the domestic United States. And for tax purposes, it's a U.S. trust. So what we say is it's offshore protection with domestic simplicity. It's tax neutral, domestic grantor trust. This is an exceedingly simple trust to manage. It's just like a revocable living trust when it comes to tax compliance. There's no 3520 or 3520A because it's not a foreign trust. It's a domestic trust. There's no FinCEN or FACTA disclosures because you don't have to open up a foreign account. So we don't have any foreign account tax compliance because we're not encouraging clients to open up foreign accounts. There's no filing requirements because it's just a domestic grantor trust, like a revocable living trust. Assets can remain in the U.S. with their current bank. So you're not trying to overcome the client's fear of offshore, overcome the client's fear of control, because clients can also be the initial trustee. And you do not have to have a foreign trustee. So the client begins as the trustee, the assets remain in the United States, and the trust remains domestic. This is a huge advantage. This is something clients have a very easy time accepting and understanding. You have not created a bunch of hurdles to try to get them to understand how to do something for their own good, and yet have created something that is inherently difficult for them to accomplish. This is the opposite. You're leaving them in control with a domestic structure that allows them to keep their assets where they're already comfortable having them. So let's test it. Is it effective? Yeah. Why is it effective? Because if the client ever has an event of duress, which would be a lawsuit or any other threat to the trust assets, the trust would become a fully foreign asset protection trust. In what jurisdiction? The Cook Islands, with a Cook Islands trustee already in place. So what you have is you have the effectiveness of an offshore trust, because at that point which the client needs to use it, the trust becomes an offshore trust. So how effective is it? It's as effective as an offshore trust, which is the most effective trust that I know of in the world. Control. Well, because we allow the clients to be the initial trustee, they have control, so they're comfortable. And by the time that they don't have control, which is when the trust is triggered, if there's an event of duress, they're fully willing at that point to not be in control, because they'll understand that that is the way the assets are being protected. And there really are two different mindset of clients. There's the mindset when you're not under threat, and then there's the mindset when you're under threat. And believe me, the client's mind is radically different under those two scenarios. Costs. The cost of the bridge trust is very reasonable. It's right about the center of the road when it comes to the initial setup fees and the management fees. So it's just very reasonable. I virtually never get any pushback on clients regarding the cost of the planning. And compliance, there's none. Unless or until we have to trigger the trust, there is no compliance, because we're not setting up anything that requires it. So what we get is we get that offshore protection with domestic simplicity. We get it in a clean structure that is really under the radar, doesn't have to file a tax return, and is very simple. So let's put it all together. Asset Management Limited Partnership, that's the holding company. The LLCs are over here, and they're going to be used to hold individual assets like rental homes, boats, airplanes, businesses, whatever the client has. The bridge trust is here. And then you're still going to use a revocable living trust. And I really think it is important to have a revocable living trust separate from the asset protection trust. The limited liability companies are owned typically 100% single member by the Asset Management Limited Partnership. This makes for easy tax accounting, one tax return, simplicity. Again, we're trying to create a structure that is not overwhelming to the client. What else goes in there? Cash, stocks, bonds, coins, collections, Bitcoin, whatever else the client may have, which is considered an asset. Who's in control of it? The client. They're the general partner of the Asset Management Limited Partnership, either directly or using a Wyoming LLC or another LLC that would maintain privacy, or simply to diversify the control group. The Bridge Trust is going to be the majority limited partner. Let's just say in this case 98%. And the Revocable Living Trust is there. So at the end of the day, when the client dies, if there's no issue, all the assets are going to pass down and through the Revocable Living Trust. That's going to do all the things that Revocable Living Trust does: distribute assets, maximize their estate tax exemptions, avoid probate, smoothly pass the assets to the heirs. So that's option A. Everything goes fine till the client dies. Option B is everything doesn't go fine and the client has some type of threat. It's a lawsuit or something else. In that case, the assets move to the Bridge Trust, and the Bridge Trust can move the assets literally offshore, physically offshore, meaning we open up a Swiss bank account. The trustee is the signer on that account and controls that account, and the assets are completely moved away from the U.S. judge, both in terms of the jurisdiction of the trust itself, which is the Cook Islands at that point, as well as the physical jurisdiction of the money. So it's really the cleanest structure I know. I can tell you internally, my statistics are that of the thousands of clients that we've worked with over the past 20 years, it's about 2% of them have needed to trigger the Bridge Trust. In other words, have actually gotten to the point where it's become necessary to pull the trigger, go offshore, open up accounts, have the offshore trustee engaged, etc. That means that 98% of them are not going to actually need to use the full thing. What I've learned is that they're using it. Believe me, are they using it? They're using it every day because it's giving them a sense of security, lowering their fear, lowering their sense of uncertainty, so that they can go out and do what they do. They're not afraid to hire. They're not afraid to fire. They're not afraid of their patients. They're not afraid of their customers. They're not afraid of their clients. They have this backup, and the amount of freedom that gives someone, just to know that you have a plan. It's literally the difference between being prepared for Hurricane Irma, which is coming through, and you have water and hurricane windows and, food and family and support, and being completely homeless with no shelter and no supplies. It's the difference. And believe me, the clients feel it. This is a practice area that I cannot encourage you enough to get involved in. It's just fantastic. Clients are so appreciative of the work that we do. They tell me all the time. They tell me how much it's helped their business, their underlying sense of purpose around what they're doing, because they know that they're building their wealth and it is going to stick around for generations. This is the cleanest top level overview I can give. This is typically how I will start an analysis with a client, with a modified and slightly shortened version of this to just frame it for the client. And you'll notice the way that I presented that was asset protection trusts, talking about the offshore trust first, talking about the pros and the cons, and then juxtaposing that with the domestic trust and talking about the pros and the cons. And what that does is it really sets up the client's mind to say, oh, I see, I want that protection of the offshore, but I don't want all that compliance and cost unless I need to. I want the simplicity of the domestic, but I want the protection of the offshore, which ultimately is what the Bridge Trust is, which is why this way of presenting things, it helps them understand the research they've done around offshore trusts and domestic trust, because there are a lot of attorneys that are jumping into the domestic trust world. Ironically, it's getting a little harder. I've noticed that there's quite a few trust companies that are less excited about being trust companies in the domestic asset protection trust world, because they're still subject to the jurisdiction of the U.S. courts. So frankly, I would not want to be a domestic trust company for a domestic asset protection trust. I think that's asking for trouble. If you're an offshore trust company, well, you don't have to listen to any domestic courts in the U.S., so it's really not as big a deal. And I think the waters are really calming down to the point where the sand is coming to the bottom, and it's clarifying that the best choice is a foreign trust, but not until you need it. So the bridge trust, to me, gives really the best option for clients to get the protection option that they need when and if they need it, but to have the simplicity of a trust that is not requiring all the compliance and the maintenance. So if you have questions, now is the time. And I've got some, so I'm just going to start reading them, and let me okay, so I'll just read them and answer them. What if the settler and major assets real estate remain located in the states where there's litigation and ownership is shifted to the bridge trust with an offshore trustee? How vulnerable, if at all, is the real estate? This is a fantastic question because it really gets to the heart of the matter. You know, if you move the control and you move the ownership offshore, and yet you leave the asset domestic, how safe is that? Well, what I would say is it's about half safe. In other words, moving the ownership and the control offshore, I have seen be effective in and of itself, actually probably more like 70% of the time. In other words, just that is typically enough to create a burden and a hurdle that is effective 70% of the time in my experience, with plaintiffs coming to the table and going, you know what, this is harder than we thought, because we have to make arguments in cases that are just, it's getting difficult. The other 30% of the time, I would say that the assets are too big and too juicy and too tempting, and since they are domestic, the plaintiffs are encouraged to fight through it and make arguments to a judge that would threaten the assets by dismantling the bridge trust, dismantling the structure. While it's almost never happened in my client cases, that's because of the way we manage those clients. So when it gets to the point where we have a threat that really is that big and we have a level of assets that really is that juicy, we are going to take steps to remove those assets from the United States. So you can do that one of two ways. You can strip the equity out of those assets, leaving them there, but with very little equity and therefore not very attractive, or you can sell those assets and just get the money offshore. While those options may seem like, oh, that's pretty drastic, I'm not sure the client's going to want to do that. If the option is sell an asset and keep the proceeds to live and fight another day, and maybe even rebuy the asset back at some point, or a similar asset, or lose the asset or potentially lose the asset and drag out litigation because you've left this thing on the table, what I found is clients are actually very willing to move from their position of I'm never wanting to sell this asset to, yeah, let's sell it. So with good management, we've actually not had virtually any cases where real estate has been the subject of litigation and it's actually been taken. And that's just because we're very careful and we're very conservative. But yes, you're pointing to a very important fact. If the asset is left here, there's vulnerability. So you cannot just assume because you have an offshore trust that you've insulated an asset 1,000%. You haven't. You've got to be willing to take steps. But what you have done is you've given your clients an option that they didn't have before. Because if the asset is owned, the real estate is owned by an LLC, which is owned by the partnership, which in turn is held by the bridge trust, and which is already 2 levels of charging order protection plus an offshore ownership structure. And ultimately, it turns out that we really do need to have that asset offshore. We've given the capacity to do that without any change of ownership. In other words, we don't have any fraudulent conveyance issues. So it is a huge bonus at that stage to have the structure already set up. Thank you for that question. That was just a fantastic question. Okay, let me go to the next question. So how does the firm work when it comes to co-counsel? Okay, that's a great question, and thank you for asking, because that's what this webinar is really all about. The way we work is that obviously we have an extensive amount of experience understanding, making recommendations, and implementing planning. We encourage you to take advantage of that. So the best way to work with us is, of course, sign up to be an affiliate attorney and get your profile up on the assetprotectioncouncil.com webpage. and then have a call with me so that you make sure you answer all your questions and details about how it works. We have an extensive library of webinars that talk about everything from how to market asset protection to the technical aspects to the case analysis. So there's a lot that can be done just through the website at the assetprotectioncouncil.com. And then, of course, I really invite everyone, to talk to me. I talk to my affiliate attorneys a lot. I mean, ones that we're working with together a lot, I'm in communication all the time. And we will spend as much time as you need to make sure that you understand how the planning really works, and exactly how what we're doing is benefiting the client. Once you've got all that, the best thing to do is identify a client and get started. And what I would do is get them on the phone with me. We'll do a joint analysis where we'll talk to that client together, and I'll make a recommendation if it's appropriate. I'll send them a retainer agreement. That retainer agreement is very clear. It's a co-counsel retainer agreement. We're both listed on there as co-counsel. It's fully disclosed to the client that we're both going to be working on the case and we're both going to be sharing the fee. I've never once had a client send that back and say, no, I don't agree. They understand. They also don't pay any more if they work through a co-counsel attorney or if they call me directly. My fees are fixed. So I do not, if client calls me off the internet and chooses to work with me, or if one of your clients comes and chooses to work with me, they would pay the same price. So there's no reason for a client to not have that extra counsel. It's my preference to work with an affiliate counsel. I find that the client gets a higher level of service, more direct support on things that I don't do, like estate planning and local funding issues and transferring issues and all the things that are very important. So that's why I'm putting so much effort into building out the affiliate program. It's because I think it's the best practice way to work with clients. So I'm just very encouraged. If you're on this webinar and you haven't talked to me yet, I encourage you to call Kitty and call me and schedule a call with me, and let's have a call. If you're on this webinar and you've talked to me and you just want a refresher, or you just want to update me, or you want to talk about some clients that we need to be making some conference calls to, just the same thing. Contact Kitty and just schedule an appointment. That's as simple as I can make it. I mean, it's really about the best of both worlds options. And I really believe that the experience has proven out over the past 20 years that the bridge trust is as effective as an offshore trust, but is so simple to manage, so easy for the clients to get comfortable with. And because of that, I think we are probably, and I'm guessing here, but I think we've probably done more trust than most any attorney in the country. We really have done a lot because it's just so easy to help a client understand how effective this is and how simple it is to get up and running. Okay, so any other questions that anybody wants to pop in before we go? I am getting ready to go and start boarding up. I'm in my office. They've already put the hurricane shutters on everything but the front door. So when I leave, they will be battening down the hatches for real. If anybody's trying to get a hold of me next week and the hurricane does hit here, you will know why I might not be returning your email or your call. I encourage you to visit the assetprotectioncouncil.com. There's all sorts of information on there. And if you have not yet seen the key concepts of asset protection, I really encourage you to watch that. You can find those at assetprotectioncouncil.com under the resources page. If you are near any of these areas in the next 3 months, I would encourage you to come and meet me. In September 21st, I'll be in the Lehigh Valley Estate Planning Council in Philadelphia, speaking to attorneys. And if you're there, I'd be happy to meet with you either at the council or just nearby. October 3rd through 6th, I'll be speaking at Wealth Council in Hollywood, California. Wealth Council, is probably most of you know, is estate planning drafting software. They really are an excellent organization. They do a great job, and their conferences are outstanding. November 15th through 17th, I'll be at the National Association of Estate Planning Council conference in New Orleans, and I'm actually the headline speaker, keynote speaker for the main stage, and again, speaking about these exact same issues. The presentation there is much more detailed, much more specific. We go into a lot of the details, and if you're going to go to any of these conferences, let me know, or if these conferences are near where you are, let me know and let's get together. Thank you all for your attention, and I really look forward to speaking with you. Please don't hesitate to give me a call, and everybody have a great week. Talk to you soon.